I'm Christophe Courchain. I'm the interim director of the Environmental Law Center here, as well as the director of the Environmental Advocacy Clinic and an associate professor of law. We're very pleased to welcome you to the presentation today. This is the last week of our Hot Topics series this year, and we really appreciate everyone who's joined us. We have one more after today. Each talk is worth 1 Vermont CLE credit, so please keep track of which talks you attend for your records. We will have a little time for Q&A after today's presentation. For those of you who are watching on VLGS YouTube, you may enter your questions in the chat space at any time, and we'll get through as many as we can. So today we're pleased and honored to welcome Robert Percival. Professor Percival is the director of the Environmental Law Program and Robert F. Stanton Professor of Law at the University of Maryland Francis King Carey School of Law. He served as a law clerk for Judge Shirley M. Hofstadler of the Ninth Circuit and for Supreme Court Justice Byron White, and spent 6 years as an attorney for the Environmental Defense Fund. He has served as a visiting professor at Harvard Law School and Georgetown University Law Center. He is the principal author of the most widely used environmental law casebook. He was a J. William Fulbright Scholar at the China University of Political Science and Law in Beijing in 2008, and has worked with China's Supreme People's Court, the National People's Congress, the Chinese Ministry of Environmental Protection, and the China Council on International Cooperation for Environment and Development. He's presented lectures at more than 30 Chinese universities, and in 2009, he represented the U.S. State Department on a lecture tour of China. Professor Percival earned his BA degree from Macalester College and his MA and JD degrees from Stanford University. Professor Percival is currently teaching environmental governance in the developing world in our summer session program here at VLGS, and will lead a group of students to China following the end of the class, which is just coming up. Today, he will present on a topic that we've been talking about all summer here, how the U.S. Supreme Court was captured by interests hostile to environmental protection. So please join me in welcoming Bob Percival.
Thanks. I'll share my screen here. And okay. The topic of the talk is how did we get to where we are now with the Supreme Court? Every year in the last several years, there's been some blockbuster anti-environmental law decision, the striking down the Clean Power Plan 2 years ago, last year, greatly narrowing the reach of the Clean Water Act to protect wetlands, this year blocking EPA's transboundary air pollution rule, and finally, explicitly overruling the 40-year-old Chevron decision on deference to administrative agencies. Now, as Christophe mentioned, I clerked for the court way back when dinosaurs roamed the earth in the 1979 term. I clerked for Justice White. He was a pretty amazing person, smartest person I ever met, also the top football player of his time when he was in college, played pro ball, and went to Yale Law School and ended up getting nominated to the Supreme Court after serving in President Kennedy's Justice Department. Things were really different back then. He was nominated on April 1st, 1962. The confirmation hearing was held a week later. It took 90 minutes. He spoke for 11 minutes. And then the committee went into executive session, announced that they had unanimously approved the nomination. And the same day, he's confirmed on a voice vote. The only thing memorable, he said, when he asked how he viewed the role of the Supreme Court justice, he said the job of a judge is to decide cases. Now, at that time, the Supreme Court didn't have any clear ideological divides. Justices Brennan and Marshall always dissented in death penalty cases and were considered liberals. White was kind of a moderate. He actually was one of 2 dissenters in Roe v. Wade, and he also dissented in Miranda versus Arizona. But you couldn't predict the outcome of cases in advance. At the time, Chief Justice Rehnquist, who he wasn't Chief Justice and he was just an associate justice, he was the newest member of the court. And he was the only one who White identified as someone to watch out for because he had a particular political ideology. He wanted to push the court to the right. And subsequently, I did research in both the papers of Justice Thurgood Marshall that were completely released shortly after his death, and the papers of Justice Harry Blackmun. And they confirmed a rumor I had heard that Rehnquist had actually tried to get the snail darter decision summarily reversed without even hearing oral argument. And it turned out the papers revealed that there have been 6 votes for Rehnquist's position that it's ridiculous to stop a nearly completed dam just to vindicate this new Endangered Species Act. But Professor Zig Plotter, making his first argument of his career, did such a superb job. He actually turned the justices around, and the final vote was 6-3 in favor of protecting the snail darter in a ringing decision by Chief Justice Burger. In another case, Rehnquist had been successful in getting the court to summarily reverse a NEPA case in the Strikers Bay case that ended up making it clear that NEPA wasn't going to have any substantive restrictions, but would just be a procedural statute. But the court at the time had actually greeted the new environmental laws with a lot of support. And this was nowhere better illustrated than in 1985, when Justice White, in the Riverside Bayview case, wrote for a unanimous court that the Clean Water Act, Section 404, did cover wetlands that were nearby navigable waters. And he memorably stated in his opinion, on a purely linguistic level, it may appear unreasonable to classify lands, wet or otherwise, as waters, but such a simplistic response does justice neither to the problem faced by the Corps nor the realities of the problem of water pollution that the Clean Water Act's intended to combat. Now, contrast that with Justice Alito's opinion in Sackett, where he does exactly what White, for a unanimous court, says was totally simplistic and ignores the purpose of the act, in saying, well, unless they're directly connected to navigable waters, they can't be regulated under Section 404. So how far the court has come in a direction that rolls back environmental protection is illustrated by that. Now, when Justice Scalia was nominated to the court in 1986, confirmation hearings still were pretty perfunctory. He was confirmed on a vote of 98-0, even though he had written just 3 years before a law review article where he made it clear that he thought environmental groups should be kept out of court, that environmental standing should be construed narrowly, because while professors in Cambridge and New Haven might like environmental law to be viewed expansively, it didn't help workers in the mines of West Virginia or auto workers in Detroit. He kind of likened them to Sunday blue laws, never even mentioned at his confirmation hearings. And true to what he had written, Justice Scalia, when he joined the court, embarked on a campaign to restrict the standing of public interest environmental groups. He also was part of the movement to broadly interpret property rights, and he narrowly interpreted federal environmental statutes. So he was not a force for expansive environmental protections in the years that he was on the court. Then, of course, we had Robert Bork, who had been nominated by President Reagan and had such a clear track record of opposition to rights of privacy, and even had a hard time explaining how Brown versus Board of Education could be justified. He insisted that he get an up or down vote on the Senate floor, even though it was clear after the confirmation hearings that a majority of the Senate would reject him, and they did so overwhelmingly, 58-42. Reagan then turned to Douglas Ginsburg, who had operated the OMB office that had tried to kill a lot of EPA regulations. But when it was revealed that he had once smoked marijuana with his students at Harvard, Reagan had to withdraw the nomination, and Justice Kennedy then became the third nominee for that seat. He was confirmed by a vote of 97-0 in 84 days. And Kennedy was the ultimate man in the middle of a court that was fairly moderate and evenly divided. The first big ideological shift on the court happened when Justice Marshall suddenly announced his retirement during the Bush administration because he was in declining health. He had famously said that I'm serving a life term and I intend to carry it out. I'm going to die on the bench, he said. But when his health got to the point where he could no longer function well, he announced his resignation, and President George H.W. Bush then nominated Clarence Thomas, who had been a judge on the D.C. Circuit for a very short period of time, to replace Marshall on the Supreme Court. Now, the Thomas hearings featured Anita Hill's testimony, and they were quite contentious. But one thing to bear in mind about the Thomas hearings was that the Democrats then had a 57-43 majority in the Senate. And yet, because of this bipartisan tradition of sort of deferring to the president's choice, they ended up confirming him by a vote of 52-48, despite the Anita Hill allegations, with 11 Democrats joining the Republicans to vote to confirm him. The court then heard some significant environmental cases. In 2001, there was a great fear that the Clean Air Act might be struck down as a violation of the non-delegation doctrine. The year I had clerked for the court 7980, Chief Justice Rehnquist had tried to revive the long-dead non-delegation doctrine by striking down a standard that had been issued to protect workers from exposure to benzene by the Occupational Safety and Health Administration, but all other 8 justices rejected the notion that the OSHA Act was a violation of the non-delegation doctrine. Industry groups tried to revive this and won in the DC Circuit by a 2-1 vote in the case that came to be known as Whitman versus American Trucking Associations. And the court unanimously rejected the notion that the Clean Air Act violated the non-delegation doctrine. In an opinion for the court by Justice Scalia, the court said we had never demanded a determinative criterion. The industry groups had been saying you have to base all regulations on cost-benefit analysis or it violates the non-delegation doctrine. So it was clear there's strong support for the environmental laws on the Supreme Court. So we had the Rehnquist court there, pictured there as it was in 2003. Now, Justice O'Connor, who had been the first woman on the Supreme Court, nominated by President Reagan, had ambitions of potentially becoming Chief Justice. Her classmate in law school, Chief Justice Rehnquist, was in rather ill health, had cancer. O'Connor went to him at the end of the 2004-2005 term and asked him if he had any intention of retiring, because if he did, she was hopeful she might get the nomination as the first female Chief Justice. He said no way he was going to retire. He was in complete denial about how bad his health problems were. So O'Connor decided that she would retire to take care of her ailing husband. And President Bush nominated John Roberts to take her seat. But then Rehnquist died, and that created another vacancy. So the Roberts nomination was shifted to the nomination to replace Rehnquist as Chief Justice, and Roberts was fairly promptly confirmed overwhelmingly. And then to take O'Connor's seat, President Bush and we're talking George W. Bush, the son of the president who had nominated Clarence Thomas, President George H.W. Bush, decided that he was most comfortable nominating his White House counsel to the Supreme Court. Harriet Miers was someone that he had known all his life. She, unlike all the other justices, had not gone to Stanford, where I went, which was the case with O'Connor and Rehnquist, or the Ivy League law school. She had graduated from Southern Methodist University Law School. And so Bush submitted her nomination to the O'Connor seat. And she didn't do very well in her initial interviews with the Senate Judiciary Committee. This is probably still the days when you didn't have the incredible preparation for grueling confirmation hearings like you do now. But there also was kind of a palace coup by the Federalist Society types who were concerned because she wasn't a strident right-wing ideologue. And so they were quoted as saying, she's not one of us. And they pressured the White House to withdraw the nomination. And she was nominated on October 3rd. And in October 27th, the nomination was withdrawn, with Leonard Leo, the co-founder of the Federalist Society, crowing that he had convinced Bush to replace that nomination with Samuel Alito, who was a judge on the U.S. Court of Appeals for the Third Circuit. Now, Alito had demonstrated fairly fierce partisanship and right-wing leanings. At his confirmation hearings, he said that Roe v. Wade was an established precedent, and he didn't express any doubts about it, although later he becomes the author of Dobbs, saying it was egregiously wrong from the start. Now, if he had been honest, I'm sure he never would have been confirmed, as was the case with the subsequent justices. But there actually was a filibuster mounted against the Alito nomination. At the time, the Democrats no longer controlled the Senate. The Republicans were in control of the Senate, but you still had to get 60 votes to block a filibuster. And yet the longtime ethos of deferring to presidential judicial picks kicked in, and there was a bipartisan cloture vote. By a vote of 72 to 25, they broke the filibuster, and Alito ultimately got confirmed by a 58 to 42 votes. Only 24 of the 44 Democratic senators supported continuing the filibuster against the Alito nomination. And with him joining the court, you see the first stirrings of right-wing activism on the court. Now, in order to ensure that he got confirmed, this group called the Judicial Crisis Network, who's almost entirely funded by money from the Federalist Society co-founder Leonard Leo, who's recently been given $1.6 billion, which is why he's doing more mischief than ever, said they'd spend $15 million on a multimedia campaign to ensure that Alito got confirmed. This is just a screen grab of their current website. And you can see they've turned into this right-wing machine of trying to oppose Democratic judicial nominees. They had launched a big campaign to keep Merrick Garland from even being considered. I'll get to that in a moment. Now they have a campaign, $10 million, highlighting how Merrick Garland, as Attorney General, did not protect Justice Kavanaugh's home. So the extremism on the right is kind of getting out of control. So this is what I called the Kennedy Court as of 2005. Why did I call it the Kennedy Court? Well, because Justice Kennedy was always the man in the middle. It was kind of split 4-1-4. If you look, for example, at one term, the term where the famous Massachusetts versus EPA decision was issued, there were over 20 5-4 decisions that term. In every one of the 5-4 decisions, Justice Kennedy was in the majority. And if you look at the entire history of Justice Kennedy's voting record in regulatory takings cases, he was the only justice that was in the majority in all 10 of the regulatory takings cases that he participated in. So he really was the swing justice, and that became quite apparent in Massachusetts versus EPA. This was the case where the court ruled 5-4 that the Clean Air Act did authorize EPA to control greenhouse gas emissions, and that states and others had standing to sue EPA for failing to do so. And who was the decisive vote in this case? It was Justice Kennedy, who said states had a right to protect their citizens against pollution dating back to the Georgia versus Tennessee copper decision 100 years ago, even though it hadn't been mentioned in any of the briefs. This case has been called the Brown versus Board of Education for the environment. And in response to it, the Bush administration did virtually nothing. But when President Obama took office, EPA adopted the Clean Power Plan to try to reduce emissions from power plants. And in what has been called a thunderbolt, on February 9th, 2016, the Supreme Court did something unprecedented by a 5-4 vote. This time, Kennedy joined with the 4 conservatives, apparently convinced by all the parade of horribles that if the Clean Power Plan was not stayed immediately, even though its first deadline for compliance wasn't until 2030, that this would result in horrible things happening to the electric power industry. So even though the DC Circuit had unanimously denied a stay, for the very first time, a litigant was able to jump over them and go to the Supreme Court using its emergency shadow docket to stop the Clean Power Plan from going into effect. And 4 days after this vote, it was the last vote Justice Scalia ever took because he dropped dead. So now, as a result of Scalia's death, you had a court that was split right down the middle, counting Kennedy as a justice often skeptical of environmental regulation, as showed by his vote to stay the Clean Power Plan. Justices Ginsburg, Breyer, Sotomayor, and Kagan were favorable towards environmental regulation. Justices Alito and Thomas probably never saw an environmental regulation they liked. Justices Kennedy and Chief Justice Roberts, sometimes perhaps persuadable, but basically a court completely split down the middle. And this was going to be the first time in almost 50 years that a majority of the justices, if the new justice was confirmed, who was nominated by President Obama, would be 5-4 appointed by Democratic presidents instead of Republicans. Now, because the Senate was in Republican hands, Obama heeded the advice even of Republican senators who said he should nominate a moderate like Merrick Garland, who was a judge on the DC Circuit. Garland, this happened right after Chief Justice Roberts, prior to Scalia's death, had warned that the court should operate not as Democrats or Republicans. They shouldn't be considered Democratic judges or Republicans. And if you have a harsh confirmation process, it could do that. In fact, political scientists rated Garland as not as liberal as Sotomayor, Ginsburg, Kagan, and Breyer. And so even though one Republican senator had said, I would welcome the nomination of Merrick Garland, the Senate Majority Leader, Mitch McConnell, decreed that no one should even meet with him. He would not be given any hearing, even though Scalia's death happened in mid-February and Garland was nominated in early March. The argument that McConnell made was it's a presidential election year and the voters should have a chance to weigh in by letting there be the election in November, even though it was 8 months off. And so no action should be taken to confirm. Well, what was really going on was that the Republicans knew Garland was a highly skilled moderate, and that if he had confirmation hearings, there would be enough public pressure following on the usual ethos of deferring to the president's nominees that he clearly would get confirmed. But they completely refused to meet with him. Now, I have to admit that some blame it falls on the Democrats, because at the time, everyone was sure Hillary Clinton was going to beat Donald Trump in the 2016 election. So there's a lot the Democrats could have done to turn up the political heat. And in fact, you recall there's a statement by President Bush on how happy he was that they broke the filibuster for the confirmation of Sam Alito. He said every nominee deserves an up or down vote. But now the rules suddenly change, and they say not if it's an election year, you don't get an up or down vote. And it was cool, okay with some Democrats who were like, well, I'm certain President Clinton will come to office and defeat Donald Trump. I mean, she did end up winning millions more popular votes, but narrowly lost in the Electoral College. And contrary to what a lot of Republicans say, she promptly conceded the next day. And so they thought, well, we'll get an even more liberal nominee in the after Clinton becomes president. But that didn't happen. And the new administration was ready to pounce. They had outsourced selection of judges essentially to the Federalist Society, got a list of right-wing firebrands. Their original list of potential justices did not include a single person of color. They subsequently amended it. But they were ready to go. Just 11 days after President Trump takes office, he nominates Neil Gorsuch, the son of the former Reagan EPA administrator who had to resign in disgrace with the various Superfund scandals. And Gorsuch was particularly attractive because as a 10th Circuit judge, he had written that we should restrict the power of agencies by overturning the Chevron deference doctrine. It was clear that there was no way he would get confirmed if the nomination could be filibustered. So the Senate Republicans promptly changed the rules and said for Supreme Court vacancies, the nominee can be confirmed by a straight majority vote. And so as a result, Justice Gorsuch was confirmed. And then the very next year, a careful deal was orchestrated with Justice Kennedy to get him to retire with assurances that Justice Kavanaugh, a former clerk of his, who was then a judge on the DC Circuit, could be the nominee to replace him. And in fact, that is what happened. Now, still, you had a court that was not totally controlled by the conservatives. And it was subsequently revealed that when Obama was in office in 2013, and Justice Ginsburg was then in her 80s and had a history of cancer, Obama invited Ginsburg to the White House to try to nudge her into considering retirement so that she could be replaced by another liberal justice nominated by a Democratic president. It's not clear whether she took offense at this, but her answer was essentially a firm no. It's not clear she was ever directly asked that, but she was having a great time. She was being lauded as the notorious RBG. One of my students, a composer, wrote this Scalia Ginsburg opera that she totally loved. And then when it became clear in September of 2020, in the midst of an election year that she wasn't going to make it. She said her dying wish was that she not be replaced until a new president is installed. Well, I guess one can say that's politically pretty naive in these times. What Trump, of course, did, even though voting had already started, early voting had already started in the 2020 presidential election, and the Republicans had refused to even give a hearing to Garland on the grounds that it was a presidential election year. The Trump administration immediately nominated Amy Coney Barrett, and her confirmation was rushed through. So she was confirmed just before the president who nominated her lost the election. Now, Democrats learned a lesson from Ginsburg, I think, and there was a campaign to get Justice Breyer to retire once Biden became president, and it was successful. And as a result, Ketanji Brown Jackson was nominated. I actually think she's one of the smartest justices. She's just been absolutely terrific on the court. Her confirmation hearings were a complete embarrassment to the Republicans. But notice, even a justice, she had been on the DC trial court and then the DC circuit briefly. Even a justice as competent as she is, the confirmation vote was 53 to 47. So it's now pretty clear that this confirmation process is going to be completely political. She was asked how do you define a woman at your confirmation hearings, attacked because of a book that was used at a school that she was on the board of trustees for. And when you realize that prior to Trump winning the election in 2016, some Republican senators were saying, well, if Hillary wins, we'll just leave that seat on the Supreme Court open for 4 years. This has all just become complete political hardball. And this is the court that we have today. And now it's become kind of a right-wing playground because there's a 6-3 super conservative majority. The 3 liberal women on the court can't even get cert granted because it takes 4 votes to grant cert. Now, occasionally, they'll peel off a justice or two. In the County of Maui case, when Ginsburg was still on the court, Justice Kavanaugh joined Chief Justice Roberts in refusing to gut the Clean Water Act. In the case staying the cross-border air pollution rules last month, Justice Barrett joined the 3 liberals. So you had a 4-woman dissent written by Barrett, chiding the majority for having intervened through the shadow docket to block a major Clean Air Act regulation with a manufactured administrative procedure rationale. But nonetheless, the court's been doing major damage to the environmental laws, to the point where Barrett felt she needed to speak out at one point and say, we are not partisan hacks, although she did that standing next to Senator Mitch McConnell at his McConnell Center in Kentucky. Justice Alito has been lashing out, saying that even the term shadow doc is an effort by the left to intimidate the court. And when they refused to use the shadow docket to stay the Texas law creating a bounty on anyone who assisted with an abortion, he angrily said that that decision was misportrayed as though we had somehow modified or nullified Roe v. Wade. Well, he knew full well the court was about to do that. He should have just said yet, because it's clear from sources within the court that the court had already pretty made up its mind that the Dobbs case was going to be the vehicle for overturning Roe v. Wade some months later. And of course, you also have the ethical controversies. Clarence Thomas, all the vacations he's taken at the expense of billionaires that have an agenda to pursue before the court. And when it became clear, ProPublica discovered that Justice Alito had gone on a fishing trip to a fancy salmon lodge in Alaska with the guy on the right, who you probably can't see because of it was Paul Singer, a hedge fund billionaire who had a $7.4 billion case before the court. ProPublica asked Alito for comment to see if this was accurate. He didn't respond to them, but he got his buddies at the Wall Street Journal to let him write an op-ed where he said, oh, they're misleading their readers. There was an empty seat. If I had not gone, there would have been an empty seat on the private jet I took to Alaska. I thought this was just personal hospitality, so I didn't have to disclose it to anyone. And how am I to know that Paul Singer had an interest in the case because his name wasn't directly on the papers? One of my colleagues, Professor Guha Krishnamurthy, has written this wonderful law review article entitled Justices on Yachts that says, you know, what's really going on here isn't that they're being bribed to get specific outcomes in the cases. It's that we know their voting record. We know they don't vote in favor of environmental regulations. So the billionaires, they want to keep them happy and on the court. It was revealed that Clarence Thomas once complained he could make a lot more money in private practice. So then the gifts started coming in to make sure he wouldn't retire from the court. John Oliver had this wonderful segment where he offered Clarence Thomas $1 million a year for the rest of his life if he would simply resign from the court. And he said, look, all these billionaires say, this is just friendship. You're our friend. That way, he says, if you're no longer in the court, you can test, are they really your friends, or are they giving you all these trips just because they want you to stay on the court voting the way that they like? I recommend watching that episode. It's terrific. Now, in light of all these ethics concerns, the court in November 2023 did adopt a code of conduct that all the justices signed off on. The problem was there's no way to enforce this. And what's happened subsequently? Well, we're getting all these January 6 cases coming up before the court. Clarence Thomas's wife, Ginny, was implicated in having sent emails to Mark Meadows at the White House asking for the election to be overturned. And they're not recusing from any of that. Thomas was the only one to vote that those emails shouldn't be disclosed in one particular case. And just yesterday, it was disclosed that he's granted quietly 2 one-month extensions of Mark Meadows' cert petition, even though his wife had been emailing Mark Meadows in conjunction with January 6th. So direct conflicts of interest don't seem to bother many of these justices. And the fact that there's no way to enforce this was illustrated by this Doonesbury cartoon that pointed out all the harm and harmful consequences of decisions like overturning Roe v. Wade, cutting back on voting rights, and the court never considers the consequences. And then the guy says, well, yeah, there is one case, there's no consequence, and that's their code of conduct. Now, Senator Sheldon Whitehouse has been waging this crusade in the Senate to try to expose how the Leonard Leo network is using its vast sums of money to basically create front groups, dark money organizations that give themselves nice sounding names, and then they file amicus briefs, or they go out and they look for plaintiffs. The court is not exactly taking cases at the behest of environmentalists. Environmentalists would probably be crazy to want to seek judicial review from the Supreme Court, given their conservative supermajority. But he looked at amicus briefs that are being filed, like in the Lober-Bright case that overturned Chevron deference. And group after group are these groups that have a connection. A lot of them, they just have a post office box address. They're funded by the Leonard Leo money. The groups seem to be expanding their efforts now. Now that they've got the court's ear, they want to dictate to the court what its agenda should be. And the court's become kind of a right-wing playground as a result. Often the plaintiffs aren't really genuine plaintiffs. We had the case involving the web designer in Colorado that said she wouldn't make websites for gay weddings. She had never been asked to do so. But that doesn't seem to bother the conservative majority on the court. The Clean Power Plan never went into effect, and yet they took the case just to make a statement by striking it down and announcing this new major questions doctrine. There's this great podcast called We Don't Talk About Leonard, it's part of an NPR investigation into the Leonard Leo network. And it opens with the night before Dobbs is issued. There's this gigantic celebration because they know it's coming. The opinion had been leaked, of course, at the main estate of Leonard Leo. And when the Attorney General of the District of Columbia decided he wanted to investigate Leonard Leo, the Republicans in the House said, no, we're going to investigate you instead, because that's a blatantly political move. Anytime the court is criticized, the Wall Street Journal editorial page and the right-wing members of Congress all say, oh, that's beyond the pale. You're trying to influence the outcome of cases by the justices, which is sort of the pot calling the kettle black, since they've been spending vast sums of money precisely to do that for all these decades now. Their latest target is they desperately want the court to intervene and wipe out all climate litigation, particularly at the state level. The courts have been virtually unanimous in saying that the new wave of state tort litigation for consumer fraud, funding disinformation campaigns about the impact of fossil fuels on climate change, they're totally state torts. The Clean Air Act doesn't have any damages provision, but the oil companies want these cases to be removed to federal court, and then they want to claim, well, the federal common law of nuisance has to apply. And as of the American Electric Power decision in 2011, it's been displaced because EPA is already regulating greenhouse gas emissions. Well, in fact, EPA's greenhouse gas regulations in the Clean Power Plan were struck down. And right now, the newest version of those regulations is before the court on an emergency motion asking that that be stayed. And none of these suits are asking for a court to try to control greenhouse gas regulations. So there's this decision from the Supreme Court of Hawaii that upheld the right of the state of Hawaii to file suit against the oil industry using a state consumer fraud claim. And not only is Leo's network funding briefs asking the court to take this case, they've actually filmed TV ads. They're running TV ads saying the court must take this case. And finally, they got the justices to agree to at least ask for the views of the Solicitor General. And they're trumpeting this like makes it clear that the court's going to take it. The one piece of hope is sort of the court has been very consistent on issues of federalism. If there's an independent and adequate state grounds for a decision, they stay out of state tort law. And they've been consistent with that. Justice Kavanaugh has, in fact, voted to grant cert and noted that when they denied cert in almost all of these cases. And it turns out Justice Alito still owns stock in oil companies, and he does recuse himself in those cases, so he's not involved, but stay tuned on this. In fact, the right wing is so triumphal it's now about the conservative supermajority on the Supreme Court that it's starting to attract really bizarre lawsuits. And this one sort of takes the case. There's actually one worse that I'll mention at the end. The Attorney General of Alabama, representing 19 red states, is seeking permission from the Supreme Court to bring an original action, it would be styled Alabama versus California, against all the blue states in which state-level climate litigation is being undertaken. Now, what gives them that right to do so? Well, they say it's a dispute between states. The court has original jurisdiction over disputes between states. And by allowing the oil companies potentially to have to pay damages in your state, you're somehow hurting us. It's like when Scott Pruitt was Attorney General of Oklahoma, he tried to file an original action against Colorado for legalizing marijuana. He said it's going to lead to a nuisance in Oklahoma because it'll be easier for people in Oklahoma where marijuana is illegal to get it in Colorado and bring it across state lines. He was shot down. The court denied leave. I'm sure the court will deny leave here. This is also the vehicle that they tried to use to get the election overturned. When the state of Texas asked to file an original action to stop certification of the votes in the states where Biden had won by somewhat smaller margins. And the court said, you have no standing to do that, and turned it down. Now, it's reported that Trump encountered Leonard Leo at Mar-a-Lago a while ago and berated him because the Trump justices did not vote to overturn the election. And so there's been a falling out there. Lately, they've tried to make friends, and I'm sure all's hunky-dory going into this election, that they hope Trump will somehow reclaim the presidency. There is, in fact, another wacko original action filed by the Attorney General of Missouri against the state of New York, asking the Supreme Court to stop the state of New York from sentencing Trump for his 34 felony convictions for fraud in his business records. And how he has a right to do it, he claims that if Trump is not only a convicted felon, but sentenced, the voters of Missouri will not have a fair choice in the election to evaluate who they should vote to. And so I would hope the court would at least put an end to this kind of wacko nonsense. Now, what are we to do? Last November, our annual environmental lecture at Maryland was given by Abby Dillon, president of Earth Justice. And she said, in talking to her neighbors about the Supreme Court, she lives in Berkeley, California, not a hotbed of conservatism. They were shocked to hear what the court's doing. Most people think this is under the radar and they don't know it. So she says, for now, at least, we can't get them outvoted, but we should lose loudly. We should try to expose what's going on, make sure the public understands that. Of course, they are doing that with respect to the abortion issue, and we hope, and we'll see how the election comes out there. Now, yesterday, President Biden, who had appointed a commission on the Supreme Court, came out in favor of Supreme Court reforms. One, he wants a constitutional amendment restricting presidential immunity for crimes. That's probably the most shocking decision of all by the Supreme Court in the breadth of immunity they gave presidents, in a way designed to make it extremely difficult to prosecute Donald Trump for trying to overturn the election by saying you can't use evidence of official acts. And if anything done in the Justice Department or the White House could be construed an official act, Biden wants a constitutional amendment to get rid of that. He also has what I think is very reasonable proposal. Our courts now are totally politicized, and one way to get the Supreme Court back would be to have 18-year term limits and space the retirements so that each president would know that he has a certain number of appointments to make. Now, they could try to do that by statute by creating the equivalent of senior status, where Supreme Court justices would still be justices, but their vote wouldn't count unless they were actually sitting and not on senior status. And he also wants an enforceable code of conduct akin to what Justice Kagan has alluded she thinks should be done, where you at least assemble a panel of other judges to make rulings, because if Clarence Thomas or Sam Alito are just deciding for themselves if they have a conflict. Alito's wife, of course, was involved in the upside down flag controversy, viewed as her stating her vocal support for the January 6th defendants whose cases had come before the court. That's the proposal. Others think it may take a constitutional amendment to get rid of life tenure on the court. But as Biden points out, we're the only country in the world that has life tenure for the justices of our highest court. So I want to conclude with this photo from quite a while ago, but it includes an alum of both the University of Maryland, where she got her JD, and Vermont Law School, where she got her LLM, specialized in energy law. I had dinner with her last night. It's always great to see her when I'm up here. This was the day they all got sworn in. I moved their admission to the Supreme Court bar. So happy to take questions now. I'll stop the sharing here.
Thank you, Bob. That was a compelling sort of series of the historical events that have led us to this point, right up to the minute, with the new proposal from President Biden. We've had a few questions come in on the chat. I'm going to see if I can sort of tee them up for you here. One is, I think, what's your sense of the role of corporate power in this sort of history, where, I think if we think back to the beginning of your story, it might not have been widely assumed that, corporations and sort of the business community would have, sort of be revivified in front of the court in a sort of throwback to the Lochner era perhaps. And now we sort of see corporations and industry groups as the key players, as if they were people on some level. And I'm wondering if you have any thoughts on that.
Well, this is statistically the most pro-business court since, back to before the New Deal era. One interesting thing, though, is that these mega billionaires who are Trump's buddies don't necessarily have the same interests as the large multinational corporations that have to answer to shareholders. A lot of environmental progress, particularly on climate in recent years, has been because of industry initiatives with companies that realize their shareholders and customers care about the environment and about climate change. Whereas the people who were going after the Clean Power Plan were the Bob Murrays of this world, who had old coal-fired power plants and were selling coal to them and just wanted to delay the ultimate day when they'd have to clean up their act. So a lot of what's been done has benefited the bad actors and not the good businesses that really want to have a good environmental track record. So the business community, it potentially is an ally on a lot of these environmental issues. And that was actually shown best in the Michigan versus EPA case, where none of the established electric utilities wanted to get rid of the mercury rule. They were already complying with it. But there were a few bad actors that just wanted to eke out a few more years without having to comply. And that carried the day with Justice Scalia in a 5-4 decision that delayed the rules for quite a while.
That's such an important angle on this sort of question of the business community's involvement at the Supreme Court. It's been interesting how there's been different camps that have appeared on different issues in sometimes surprising ways.
One other thing I should mention, I forgot, when Trump had that encounter with Leonard Leo at Mar-a-Lago, Leo's reaction was, "Oh, that makes this look all so transactional," that Trump was demanding a quid pro quo of having the election overturned by his justices.
Well, sort of sometimes you get what you pay for, I guess, in that realm. I think one other topic that's come up in the chat is this nomination process. And I guess as you look back on this history, is it better that we currently have this sort of very contentious, politicized process now where we're really, it's really become very partisan? Do you look back fondly at the days of, sort of very little scrutiny of the justices being proposed for the court, and having that process be smoother and more collegial? I'm sort of curious your thoughts on that.
Well, I long for the days when you couldn't predict the outcomes in advance, given ideologies on the court. It would have been nice if someone had raised Scalia's law review article about why we should keep environmentalists out of court. The idea that he was confirmed unanimously and that wasn't even mentioned is kind of surprising. There were some pretty gingerly questions of Barrett and Kavanaugh about climate change. And I believe Kavanaugh said, well, the Pope is concerned about climate change. Barrett pretty much refused to answer. Her father was an oil industry executive, and she had authored an opinion that said we don't have a right to nature like they have in the Ecuadorian Constitution, and kicking out a case on standing grounds where both sides agreed there was standing. So I'm kind of worried about her environmental standing. But I actually think her dissent in the good neighbor rule stay shows that she's starting to get it about what's going on with justices like Gorsuch, where they're just making stuff up to try to find a violation of the APA because they just want this outcome that's to stop the regulations. So, there may be hope for her. And Roberts is hard to understand because, in the Sackett case, that's where I was so disappointed in him. Kavanaugh sided with the dissenters in the Sackett case. But Roberts, who in the Rapanos case in 2006 had said, if only EPA or in the Corps would promulgate a clearer rule. Well, they did. They went through years of rulemaking, and it's entirely ignored based on everyone embracing Alito's notion. Well, the word wetland has this certain meaning, which Justice White for unanimous court had said that's way too simplistic and ignores what the act's all about. And that's where we're at now.
So maybe for our final question here, what are the prospects for these accountability mechanisms that seem to be in the air, the ethics code, the potential for term limits, the sort of, there are impeachment resolutions, right? So all of that suggests a heightened public interest in what the court is doing, but also, as you pointed out with Justice Alito, quite a bit of disinterest in those accountability efforts, and particular institution seems very impervious to this type of criticism and scrutiny. So I wonder what you think about the prospects for that, and if there's a path forward on accountability.
Well, I think eventually there has to be a grand bargain on term limits. And if you do it so that each president has a certain number of appointments, I think that would diffuse a lot of the partisan fighting, because you would know in advance what the consequences were going to be in the future. But that would require the kind of grand bargain that would probably, to get a constitutional amendment through 3/4 of the legislatures, even in red states, if it looked like the liberals were going to take over. The absolute quickest way to deal with it would be, you can add justices to the Supreme Court by simple majorities in both houses signed by the president. The Constitution doesn't say how many justices there has to be on the court. So you could make it 13, which is actually the number of circuits that we have in the lower federal courts, would make some sense. But of course, the fear is if the Democrats did that, then the Republicans, when they took over Congress, could come back and do it. And we'd be like the Supreme Court of Argentina, ever expanding and shrinking. Carlos Menem appoints his tennis director as a justice. And, don't necessarily want to go there. But the ethics is something that, I think Kagan's right. It could be done. There have been cases like when there was a lawsuit brought over the failure to provide cost of living increases for judges. The rule of necessity was invoked because otherwise justices would have to recuse themselves, where you can have some input from lower court judges on ethics issues, at least. But transparency is, at least we're at the point now where they have to disclose these trips. It's not considered like having someone over for dinner at your house, which has been the line they've been taking all these years.
Well, so maybe a pathway to some greater transparency and accountability, but we'll see. And this is the story, obviously, will continue. And so we are out of time for today's talk. And thank you, Professor Percival, for your presentation. It was extremely enlightening and it's a great story, even if it's
sad.
We're in a bit of a challenging spot right now. So thanks again to our viewers for joining us today, and for your questions. Our final talk of the summer will take place online on Thursday of this week, same time, same place. And so thanks again for listening, and have a great day, everyone.